So first, law helps us at better understanding law as a phenomenon. Comparative law helps us to consider law not just in the confined limits of positive law, but law as a phenomenon. Usually, when we study law at universities, we study our national positive law. I remind you that by positive law, we mean the law that is posed by the legislator and is implemented in a certain time and place. And the concept of positive law is usually opposed to natural law, meaning that the positive law is the law which finds its source in the legislator, a law that is posed, une loi posée, droit positif. So when we study positive law in universities, we are confined to our own national law. To a given legal problem, we will study only the solution provided by our own national positive laws. So we have no way to examine or to evaluate the solution. Or if we want to evaluate the national positive law solution, we would not have the necessary tools or necessary knowledge. But if we try to solve the same legal problem by a comparative law paradigm, which means that for this given legal problem, instead of just studying our own positive law solution, but we also see what other laws provide as solution, here we rise above our national positive law and we can compare our own solution to other solutions. System C might give a different solution. System B, the legal system B, the foreign legal system B might give a different solution. This way we can compare between these solutions. Our own positive solution with solution of other systems. Therefore, we can evaluate our own solution. We can see the flaws of our solution, or at the contrary, the flaws of other legal systems. Comparison by itself is a very important pedagogical tool. It helps us better understand any topic, not just in law. When we compare, we get a better understanding of the topic we are studying. As a matter of fact, comparative law rises above positive laws. And that's why sometimes it is considered as a threat to positive law. So positive law thinks of itself as a complete autonomous system, while comparative law comes and tells us by comparing different positive laws, it tells us that no, this positive legal system has its own flaws. But this has also a positive side, which means that we can now ameliorate our own positive legal system. Which leads us to the second function, which is comparative law as an aid to the legislator. Comparative law helps the legislator at modifying national laws. As we said, comparative law at first tells us what are the flaws of our positive law. And the legislator will then modify our laws, abrogate certain laws, substitute them by others, introduce new laws. And in doing so, the legislator must do comparative legislation. So here comes the importance of comparative law as an auxiliary to the legislator at helping this legislator finding better solutions, better modifications, better transplants. In this sense, scholars usually speak of comparative legislation instead of comparative law. Why would a legislator resort to comparative law? We can talk about two reasons why. First, emulation. The idea of emulation takes us back to the notion of imitation, which we saw earlier on. So why would a country emulate another to adopt or adapt better solutions? The legislator sees that another country another legislator has better solutions, so we emulate that other legal system and we bring in their legal rules or institutions. The second reason is competition. A legislator might find that its own laws, its own legal system is no longer competitive. So the legislator does a little comparative research in order to modify and ameliorate its own laws to become more competitive. In concerning this point, we can refer to the School of Law and Economics and Law, l'analyse économique du droit, and its notion of efficiency. A legal system has to be efficient, and the legislator will always modify its laws according to this goal of efficiency to become more competitive. We shall see a couple of examples. When it comes to emulation, we can give the following examples. The Torrens system, the Torrens real estate system, السجل العقاري, le livre foncier, which of course granted Lebanon more security, more legal security when it came to real estate transactions. The unipersonal company, also it was grafted into Lebanese law from French law. The unipersonal limited liability company, la société unipersonnelle à responsabilité limitée, in order to improve entrepreneurship in Lebanon. There's also the law about securitization, titrisation, تسنيد الموجودات. And here we can read in the motives of the law how the Lebanese legislator emulated the American legislator and few European legislators, because this notion of securitization or titrisation in French proved to be a successful notion. As examples for competition, we can mention the offshore companies in Lebanon. Lebanon, in order to be competitive, had to promulgate a law decree organizing offshore companies. Another example about competition would be the French reform of the French Civil Code in 2016, because the French realized that the French Civil Code ceased to be a competitive model. Countries who were seeking to change their civil law no longer were imitating the French Civil Code, but they were going toward common law or the German Civil Code. Therefore, the French said, let's reform our civil code in order to keep it competitive, to keep it more attractive. You can pause the video and read these few lines taken from the report to the President of the Republic in France related to the reform of the civil code, where the attractivity of French law was one of the major goals of the reform. Logically, before the legislator even tries to emulate another legal system or tries to transplant something from another legal system, two questions has to be asked. Is this legal institution or legal transplant successful in its country of origin? For instance, in Lebanese law, the reformists of the commercial code should have asked, is the unipersonal company successful in France, before trying to transplant it in Lebanon? The second question would be, to what measure is it possible to transplant this foreign institution into our country? Here's the country of reception. Here I can give the example of fiduciary contracts. In 1997, the Lebanese parliament voted, and the president promulgated a law related to fiduciary contracts. Fiduciary contracts are very successful in common law countries, but can we transplant them to Lebanon, where our notion of ownership is different from the notion of ownership in common law? That was a very debated question back then.